I'm sorry, does this happen? No, it's fine. I'm not trying to.
Yeah, we'll get you a copy, but I mean,
You're welcome.
it was missing some stuff related to that. Like, I don't think it had all of Lindsey Burton's findings for the original investigation related to Elizabeth. So, yeah, so there's more of them that are on the additional CPS records, which include the stuff in the new trial.
I see. Okay, thank you. I'm sorry, I'm trying to concentrate on two different things at once, and I'm no good at that.
Okay, I can't imagine having to duplicate this. I'm glad you found it. You're welcome. Yeah. All right, Mr. Navy, do you have the have a copy of it with you or no?
I gave it to somebody, should be around. I have a copy of it with me, but Lupe was printing it out.
Okay. Okay, who's raveling stuff? I don't think it's me. I could be wrong though. And Mr. Wood, who is your client?
Stillman, Judge.
All right, so we're going to take Stillman first. And then we'll do Harrison. And as soon as I get your Mr. Navy, we'll take that.
Thank you, Judge.
Yes, Judge.
Yeah, cool.
Yes.
Asking for a bond with each stage in this court on the 29th of August. He's had COVID 3 times, so far this year.
All right, can you have the clerks pull the file? Sure,
I
So you have-
thought that he couldn't find the VA file.
that's okay. All right, you want to pass it to me? I thought the name of your case was Bass.
No, that's just the complaint.
So it's been sitting here, but we won't tell anybody. All right, you want to come forward?
Yes, sir. I want the other one.
Are you ready?
This is the-
Yes. Miss Bass, I need you to unmute and show your video, please.
this is- it's coming-
Court is calling CM 1000272 and CM 1000271, State of Texas versus Stephen Marshall. Could I have parties announced for the record for the state,
Catherine Pollard for the state.
for the defense?
Nathaniel Navy, Your Honor.
That's not.
And are you Mr. Marshall?
Yes, ma'am.
All right, we're here with a request to modify bond conditions. The defense is asking that the no contact order be removed. State, have you seen the motions?
Yes, Judge.
Do you have any objection?
No, Judge.
All right, defense, why are you requesting that this be removed?
Judge, these two have been in a relationship for about 11 years. Mr. Marshall was living with Whitney Bass and her grandmother, Cornelia Bass. Obviously, now that there's a no contact order, they're not together. All parties want this removed, Judge. There's nobody that wants this in place. And so I would just ask that if you could alter and amend it to be no harmful or injurious conduct rather than no contact whatsoever. And the state's spoken with the complaining witness and they don't have any objection.
All right, and have you also spoken with Cornelia Bass?
I have not. I've only spoken with Whitney Bass this morning.
All right, and so would he be living with Whitney Bass and Cornelia Bass?
Would, yeah, and I believe that she can appear on the Zoom as well. They're
Oh,
together.
well, let's have Miss Bass on the Zoom as well.
And I have affidavits from Cornelia and Whitney Bass stating that these are their desires, and they're just on Zoom to confirm that with you, Judge.
Take your roll off.
All right, Miss Whitney Bass.
Yes,
you
ma'am.
raise- Ooh, you can lower the volume. Can you raise your right hand for me, please?
Yes.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Whitney Bass.
All right, you can lower your hand. All right, the defense counsel is asking that the no contact order be lifted. It's the court's understanding that you've spoken to the state. Is that correct?
Yes, ma'am.
All right. Do you have any fear of Mr. Marshall having contact with you?
No, ma'am.
All right. Is there anything that you think he needs to be successful on bond?
No, ma'am.
All right. Any questions from anyone else?
No, Your Honor.
All right. Court will call Cornelia Bass. Could you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
You can lower your hand. Could you state your name for the record?
Cornelia Elizabeth Bass.
All right. So the defense attorney in this case has filed a motion to allow Mr. Marshall to have contact with you. Do you have any objections to him having contact with you?
No,
All right. Are you in any fear if he were to have contact with you?
oh, absolutely not. No.
Okay. All right. Thank you. Any questions from either side?
No, Judge, you covered it.
All right. Thank you for coming in. All right. I will grant the order. I want to tell you, if there are any issues at that household, what could end up happening is you could be answering for these charges while you're in custody. Do you understand? And I don't take anything with regards to your case as true because I haven't heard any facts of the case. But what I'm telling you is that whatever caused this situation to happen, I find that it usually still exists unless people address it. If there was some kind of argument, then that needs to be addressed in a calm, cool, collected manner. Do you understand?
Yes, ma'am.
All right. Is there anything else?
No, Judge,
All right. Thank you.
thank you.
Okay. I'm just waiting for these two and then we will start. John Young.
Your Honor, I am afraid my magnolia is going to feel bouncy. I think you've been unfaithful to it.
What's happening with your magnolia?
Magnolia is doing well. It's the peanut size seed pods have not changed. I'm actually seeing like 1 and 2 of those little red seeds on each seed pod, which is embarrassing because they're usually loaded with them.
Make sure that Ms. Ferguson gives you a reset date. A reset date.
I shall.
All right. Thank you.
I think we may already have one. But I'll
Mm.
check.
It just has it listed in the file as the 25th.
Thank you, Your Honor.
You're welcome. All right, Hillary Stillman, if you can come forward, please.
Peace present, Judge, we're ready.
All right. And is this a plea on 2 cases or 1?
Just one, Judge. I think the other-
All right, court is calling 2022 CR 9437, State of Texas versus Hillary Stillman. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
So what on behalf of Mr. Stillman, who's present, we're ready.
All right, counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor.
Mr. Stillman, I'm showing you what's entitled application for probation. Did you review that with your attorney? Did you understand it? Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? State, are you proceeding on the indictment as presented?
Very nice.
And defense, are you waiving the reading of the indictment?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Stillman, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1, 4 grams to 200 grams? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court doesn't follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you any defenses to this offense?
We've discussed the case, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Stillman, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea? Thank you. Are you satisfied with the way you've been represented? Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, your punishment is to be assessed at 5 years in the prison. There's a $1,200 fine that is to be probated. There are no applications for deferred adjudication. State recommends community supervision. And there's restitution of $57 to SAPD for lab testing. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor. I'd like to address it. Oh, if I may.
Yes.
Judge, this young man, he's 43 years of age, he's from Hanover, Texas, has a GED. He was in San Antonio. He's been diagnosed and is under medical care for schizoaffective. In addition to other ailments, he's been taking some pretty strong medication. Currently, you would reside at Haven for Hope. They have a Center for Healthcare or CHCS program for your diagnosis, which you've been participating. He would like to return to that.
Okay.
And for that reason, that's why the fine is probated. He had a commercial driver's license, but due to his illness, you're not able to keep the commercial driver's license. He's looking for jobs now, but Haven Hope help him with that. So he's in a program.
Okay. And is that the plea?
Yes, Your Honor.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. State is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 120 hours of community service restitution, and a drug court evaluation. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, state offers State's Exhibit 1 in all attachments.
We've had an opportunity to deal with him. No objection.
Mr. Stillman, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments. The court has reviewed the same. The court is finding there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We might.
All right, Mr. Stillman, do you have any children? All right. Do you have any family here or no? Where's all of your family? All right. Do you want to go back there or do you want to stay here?
Eventually, after this is cleared up.
Okay, because if you want, your probation can be transferred there.
Later on in the probationary period, possibly.
Okay,
Because right now, separation of issues and families would be more appropriate.
all right. The court is going to sentence you to 5 years probation. Oops, I'm sorry, 5 years in the prison, suspended and probated for 5 years, $1,200 fine probated, restitution of $57 to SAPD, 120 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. Proof of employment or SSI within 35 days. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. You to reside at Haven for Hope. And what's the name of the specific program he's in under Haven for Hope?
It's actually a combination, actually patterned after DDR.
Okay. We're going to do a TAP evaluation that can take place out of custody. If TAP recommends inpatient treatment, then we're going to start with intensive outpatient treatment and sober meetings. I'm going to want a MIC evaluation, and that can be out of custody. Field visits 1 time per month or as deemed needed by probation. Regular reporting in person or by Zoom, and random UAs. Probation, is there anything else he needs? Mr. Stillman, is there anything else you need from the court in order to be successful? All right, good luck to you, Mr. Stillman.
Hardship. Supervisor. Just read it.
Well, I tell you what, Mr. Stillman, just make sure you do everything else that's on probation. Always work with people with regards to fees. That's never held anybody back from being successful. All right, thank you. And Mr. Wood, always a pleasure to see
Thank
you.
you, Judge. You as well. Thank you.
All right, here, thank you. All right, the court is going to call Edward Ugarte.
Right.
All right, and this is not an application probation. Court is calling 2022 CR 7460 State of Texas versus Edward Ugarte. Can I have parties announced for the record for the state? Just anyone? Anyone from the state? For the defense?
Judge Richard Garcia for the defense.
And are you Mr. Ugarte? Defense, have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor, we did.
Court will find that the state is in compliance with discovery. Mr. Ugarte, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor, we only have one correction addition. Mr. Ugarte's real name is Eduardo, not Edward. And it's spelled EDUARDO. Eduardo.
Okay, thanks for rolling the Rs. All right, State, it appears that you're proceeding on the indictment as presented. Is that correct?
Yes, Judge.
Mr. Ugarte, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand you're charged with violation sex offender registration annually? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you and your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand? Did you understand by entering this plea, you were giving up those rights? And you're going to need to speak up.
Yes, ma'am.
And did you intend to give up those rights and enter to a plea bargain in this case? Counsel, has your client been able to provide you with any defenses?
Yes, he has, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Ugarte, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Promised you anything other than the plea bargain agreement? Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, punishments be assessed at 2 years in the prison. There's a $1,500 fine, no applications, and chapter 62 compliance. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest? State any evidence?
Yes, Judge. State Exhibit 1 and all attachments.
No objection, Judge.
Mr. Ugarte, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state will call on the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court is finding you guilty. Proceeding with sentencing.
Yes, Your Honor, asking that you waive the PSI.
All right, court is sentencing you to 2 years in the prison. There's a $1,500 fine, time and money to run concurrent, and chapter 62 compliance. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. We're off the record. Here's the thing. Sometimes people think their life is over, so they just say, I'm just going to do what I want to do because my life is over anyway. Sometimes, guess what? You end up being here for longer than you think you are and last longer than you think you did. And you're going to find yourself in prison for the rest of your life. Don't be that person. Good luck to you. All right.
Judge.
You're welcome. Always nice seeing you, Mr. Garcia.
Likewise.
All right. Who's here on James Orness? James Orness Harrison. Who's the person? Who's your attorney? David Garcia. Okay, just wait here. And who's the person in the box? Yes. All right, Roger Campos, come forward. All right, so what is going to be happening with this other case? Because I have a violation report. And the violation report is you're actually been arrested in 2 misdemeanor cases. So defense, what is going to be happening with this felony case?
Judge, I was conferring with the state. I believe they have to check in with the complaining witness, but depending on how that conversation goes, we will have an offer that would get rid of all cases, Judge.
All right, so when do you think this will take place?
Judge, we've already attempted to contact the complaining witness, and we're gonna try a couple more things.
Okay,
Just 2 weeks, we should have an answer.
all right, so if you'll see with Ms. Ferguson to get a 2-week reset, and we'll go from there.
Yes, Judge. Thank
Thank
you.
you.
You're welcome. All right, and I think all the jurors here?
Yes, they are, Your Honor.
Okay, so after they go back, we'll bring the jurors in and start up with trial. And Mr. Harrison, just give me a moment and we'll take care of your matter.
Campo.
Can you see if Luke is Norma has already left?
Yes.
Yes.
Yeah.
Okay. All right, Mr. Harrison, can you come forward? All right, okay, thank you. Bye-bye, have a good one. All right, Mr. Harrison,
Yes, ma'am.
I'm going to recall your case. Because, yes, because your attorney is not here and we can't go forward without your attorney. So I'm going to recall it for November 1st. Yes. But thank you for showing up.
I was here yesterday too.
I
I was a
know.
little bit late, but I was here. I showed like 9:17.
Okay, so we'll bring you back on November 1st. Okay. All right, can you go back to?
They don't vacuum.
All right, defense, who is your first witness? Who's your first witness?
It will be William Anderson.
All right, Mr. Anderson, if you can come and take the stand, please. All right, thank you. Yeah, just have a seat.
Okay, that's a gross picture of the bone. Well, he took, yeah, but he's, the child has this on both sides. Yes. So it could be metabolic related. So that's why you get somebody that knows what they're looking at to look at the microscopics. Have something to do with the way the kid's growing.
Ready?
All right, for the jury.
All right, everyone. Please be seated. All right, so you guys have stopped switching up on me. Everybody's staying in their same seats. I'm sorry, I know I said we would start at 1:30 and we're getting a little bit of a late start because our morning docket bled a little bit into the afternoon docket. And I always like to give people a chance to at least grab some food on the run. All right, defense, are you ready to proceed?
Yes, Your Honor.
All right, call your witness, please.
Call William Anderson.
All right, Mr. Anderson, if you could raise your right hand for me, please. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth? Will help you God?
Swear.
All right, you can lower your hand, and if you could state your name for the record, please, and spell it.
William Robert Anderson, Anderson.
All right, defense.
Thank you, Your Honor. And Dr. Anderson, tell us, are you a doctor?
I am a physician. I practice in the area of pathology.
Okay, so you are would we commonly refer to you as a medical examiner?
Well, pathology involves basically the study of disease processes through looking at tissue diagnosis and laboratory diagnosis. A pathologist reads biopsies, does autopsies, runs clinical laboratories and that sort of thing. A forensic pathologist or a medical examiner is basically a pathologist who's gone up through the first part of the training of the anatomic part, the tissue part, and the laboratory part, and then is specialized in the area we call forensic pathology. That's medical interfacing with the medical legal system, and that's essentially what a medical examiner is.
Okay, and tell us about your background.
Well, I attended medical school at the University of Miami. I trained in pathology at the University of Rochester, New York, and that was the anatomic part, reading biopsies, doing autopsies and so forth. And then I trained at the University of North Carolina and Duke in cardiovascular pathology, that's pathology of the heart, and also clinical laboratory medicine as well. I did that at Duke and UNC as well. And I am board certified in the anatomic part, the clinical part, and then after my pathology training, basic pathology training, I did a year as a medical examiner at the State Medical Examiner's Office in North Carolina. So that then I was able to take the exam then to become certified in forensic or medical legal pathology. I've been
from there, where did you go?
Well, I've been practicing since about 1976, and I'm presently practicing. And I've been medical examiner in California, Georgia, and Florida. I was deputy chief medical examiner in Orlando area for the 90s into the early 2000s. And I was director of their training program where we brought pathology residents who were in their training. They came in and did a year with us, and then they could take the exam for forensic pathology. So I directed that program. And since then, I've been in private practice. I do basically the majority of my private practice now is reading biopsies for in the gastrointestinal tract, stomach, colon, and so forth, biopsies. Tract. Involving stomach biopsies, intestinal biopsies, and so forth. So I also do private autopsies, and I have covered on occasion for medical examiners, offices or out of the state of Florida who needed part-time coverage. Essentially, that's what I'm doing now.
Okay, and can I ask you, I think the court reporter is having a little trouble keeping up speed-wise. Can you slow down just a bit when we
Sure.
talk? Thank you. And then have you done any, sorry, I say done, have you conducted any peer-reviewed studies, written journals for peer-reviewed, articles for peer-reviewed journals, that sort of thing?
Well, actually, I've done a few articles, but majority, a couple of chapters in textbooks. But when I was with the medical examiner's office in Orlando, we developed a program of interfacing with the trauma surgeons and trauma doctors, because when the patient would come in, Orlando has a level 1 trauma center, which means from that whole area of the state, they're bringing their trauma cases. And anytime a trauma victim died, it would become a medical examiner case. So we had conferences going for a number of years with the trauma surgeons where we would they would come in and see the results of their autopsy. They'd see what some of the complications of the trauma was. And then they'd be able to go back and basically, if they had a patient with similar injuries, they knew sort of what to expect and could maybe get it intervened so you would have some of those complications wouldn't occur. And so the patient would walk out of the hospital vertically instead of horizontally, essentially. So I was asked then to write a textbook on clinical forensic medicine, which I finally ended up finishing around the year 2000. And that was dealing with exactly the same situation, letting clinicians know what some of the pathology findings were on patients that had certain type of injuries, certain distribution of injuries, and what they could expect. And also letting the medical examiners know that there was a clinical aspect of the whole situation in evaluating a case as a medical examiner. You had to go back and look at all the clinical data too, to see what was happening in the patient in the interim between the actual injury and the death, if it was a death case, and also what interventions of the doctor's treatment might have altered what you're seeing as the medical examiner at the end of the treatment, because sometimes we'll go on for months. So you'd have a lot of changes going on. So it's important as medical examiner, that you recognize what those changes were and any discrepancies that might occur, then you can go in and analyze those and decide what else was going on. So you come up with an accurate diagnosis, essentially.
Is there a name for that where medical treatment cause changes in what you're seeing as a pathologist later?
Well, yeah, the term for basically it's called iatrogenic, which means the medical care has caused certain changes to occur, sometimes trauma, not because there was necessarily incorrect treatment, but just because in the handling of patients in critical situations, particularly, you get changes that occur. And as a pathologist, you got to make sure you recognize those and don't misinterpret those when you're doing the autopsy as something that may have occurred earlier.
Just as an example of that, there's been testimony in this case from Dr. Gebhardt that it could have been, and that it was consistent with the pneumothorax, the collapsed lung that Olivia suffered.
I'm sorry, I'm having a little trouble hearing you,
I'm sorry. The pneumothorax that.
which is unusual for a lawyer, but
Can you hear me now?
yes.
Okay, so there's been some testimony in this case, just to give an example of what you're talking about, that the pneumothorax that Olivia suffered was consistent with having been.
Sustained,
Judge, I'm talking about the testimony that was given by Dr. Gebhardt.
sustained.
Okay. So any testimony that, I apologize, any treatment that is given by the hospital that causes a difference in what you would see as a medical examiner
That'll be overruled.
is called what again?
It's called iatrogenic.
Iatrogenic. All right.
And you need to recognize what is iatrogenic. And sometimes that means going back and looking at the medical records pretty closely to see if, what treatment has caused what changes. That's why it's very important for the medical examiner to have a very close liaison with the clinician so they know what the various treatments are doing and what changes can occur because of various treatments occurring.
Okay. Now, and you said you wrote a textbook on that subject, is that correct?
Correct.
Okay. Now, were you appointed by the court in this case to both as a consulting expert to help the defense understand all of this, and also to sort of redo the autopsy in this case?
I'm going to object to defense counsel testifying in a misstatement of evidence.
All right, that objection will be sustained. Ladies and gentlemen of the jury, sometimes documents are given to the court where people are asked for funds in order to hire experts, and the court will sign documents to appoint experts that are requested.
Okay, so were you appointed by the court to redo the autopsy in this case?
Well, no, I believe I was appointed by the court, but my understanding was to simply review the case and give my independent opinions as to what the case was occurring.
Okay, and my point there is you're not being paid by, you are being paid in this case, correct?
Hopefully.
Okay. And you're not being paid by Jessica Briones, correct?
That's correct.
Okay, does the fact that you're being paid by anybody give you, does that alter your testimony in the case?
No, when I testify as an expert, I'm basically giving my opinions, and I'm paid for my time, but not for opinions. It doesn't matter what my opinions turn out to be. I'm still charging for my time, essentially.
Okay. And you've testified in other cases, correct?
Well, yes, as part of what a medical examiner does is interface with the judicial system. So I've testified in hundreds and hundreds of cases. In Orlando, for instance, in a given year, we had 3 medical examiners and we'd probably have 100 homicides. So we'd probably have at least 30, 40 homicides apiece per year, and I was there for 12 years. So we would invariably, if we determined the case was homicide, which is what the medical examiner does, determine if it's a natural death, homicide, accident, suicide, whatever, then we would testify and normally be called by the state to testify. So I've testified in many, many cases. Primarily, the vast majority of the times I've actually gone to court have probably been, when I was called by the state to look at a case that we had done as an autopsy.
Okay, and so in those hundreds and hundreds of times, were any of those cases related to deaths that were the result of child abuse?
Well, a significant number were, well, the child abuse cases are fortunately a minority of the homicide cases that we do. But we look at the same, anytime we get a child death, one of the important things is this a homicide or is this something else? So we evaluate those cases the same way, not necessarily saying, well, this is a homicide, so we're going to do this, this, and this, or it's not, so we're going to do this. If you're going to do scientific accuracy and come up with accurate reports, you've got to do the same thing all the time. You do the complete all the time. And then you make your conclusions as to what you might think it would be. But I would imagine I've probably done, probably at least over my career, I've done about 7,000 to 8,000 autopsies by now. And probably a good 5–10% of those are children deaths, not all child abuse, but cases where there would be trauma to a child or a child just dies suddenly and there was no expected reason. And then we would evaluate to see if it was or not. In the majority of cases, it turned out there was a natural process that caused the death.
And you bring up an interesting point. Is an autopsy always done when a child dies?
In most jurisdictions, it is, unless the child has, for instance, a terminal illness, a terminal disease, has been diagnosed medically. Basically, if it's a sudden, unexpected, unexplained death, or suspected trauma or actual trauma, then the medical examiner in most jurisdictions around the country would evaluate those cases. And almost always we would do an autopsy on a child just because of the importance of making sure there aren't any underlying problems, and for a number of reasons, including, genetic potential problems and so forth.
Okay, and did you review, well, first off, did you review the autopsy records in this case?
Well, I reviewed the autopsy records, the photos, microscopic sections. The medical examiner's office provided me with, when we do an autopsy, we look at with the naked eye, and then we also take tissue to look at under the microscope, like I would do every day doing biopsies. Okay, so we would look at those under the tissue, and the medical examiner's office in Bexar County provided those slides. So I looked at those as well, the same ones that the medical examiner would have looked at during the autopsy.
Okay, and then also, did you also review the rest of their file?
I'm sorry.
Did you review the rest of the Bexar County medical examiner's file?
I believe I did, yeah.
Okay, and what other documents did you review?
Let's see, I think the major ones I looked at were the medical records from the admission, the final admission of the child.
And by final admission, you're talking about the records of the 5th of September of 2017.
I believe that's correct, yeah. I got electronic versions, and sometimes those are different than the printed versions, but it was the final admission records from the child.
Okay, and so let's talk about a couple of findings from your review and some of the findings that you made, as well as findings that you reviewed. All right. Okay. Let me ask you, Dr. Gebhardt testified in this case, and he testified in this case that he believed that Olivia may have suffered from.
I'm just going to object to defense counsel pleading questions.
Sustained.
Judge, I cannot just so I'm clear on what I can do and can't do, you're saying that
You cannot ask leading questions.
I'm not asking a leading question, Judge.
All right, the objection is sustained.
Okay. If Dr. Gebhardt testified, and you can answer this either way, and I'm not trying to suggest an answer, but if Dr. Gebhardt testified that that he believed that there was a diffuse axonal injury in this case, is that something that you would agree with from your findings?
Judge, I'm just gonna object to defense counsel's pleading.
That'll be overruled.
No, in examining, in looking at trauma cases, there are really two, and they're not black and white because there are intermingling. There are two types of head injuries that are going to occur from a moving head. Now, of course, you can be hit over the head. That's a whole different story. But if you're a moving head injury, the brain can bounce back and forth within the skull, okay, because the brain's just floating in there. But where the brain is floating and the dura, which is the lining of the inside of the skull, there are little veins that go back and forth. They're very delicate little veins. And a moving head can start tearing those veins. When somebody falls, hits their head hard. The brain bounces back and forth, and then you begin to get bleeding. And this is what's called a subdural, or beneath the membrane, which is called the dura, in the brain. And this can occur from low velocity injuries. And what happens is then as the blood expands and gets bigger, it's within a contained skull. It's a container, essentially. It doesn't move very well. So the brain will be compressed by the expanding subdural hematoma, or bleeding under the dura. And as that occurs, then the brain is compressed, the pressure gets higher, and the higher pressure inside the brain, the less oxygen it's getting, the blood flow is being slowed down, so you don't get as good blood flow. And that basically causes the brain to start swelling, and that's called a low velocity injury. A high velocity injury is we see it in automobile accidents and in traumatic child abuse cases where the head is forcefully thrown into something or banged multiple times. And basically the brain is injured so quickly that it swells very quickly. Now you still get that subdural blood starting to occur, but in a diffuse axonal injury, or DAI, the brain swells so quickly that it stops the bleeding. So what you see is a film of blood and not an expanding mass. And when you look at the brain under the microscope, you see certain specific findings that the brain, around the little vessels inside the brain, you see hemorrhage. We did not see that in this case. And if you suspect diffuse axonal injury, you can do special stains. You take another piece of the tissue that you've saved, put it under the microscope, put a special stain on it, which in the case of, if you're looking for diffuse axonal injury, it's called beta amyloid precursor protein, or APP, but that's just the protein that's released. That's what it's called. But you can stain for that, and then you will see under the microscope, you'll see little balls forming where the neurons have actually been torn. They did not do this in the case because the medical examiner didn't suspect it, and frankly, I probably wouldn't have done it either because this looks.
Object to the witness speculating as to what the medical examiner thought.
Right, that will be sustained.
Are you basing that on the report that you've read, the autopsy report that you've read?
Correct, and plus the fact that we asked for all the slides, and I got no special stains back indicating that he would have done those stains.
And Dr. Feig testified, the one who did the autopsy testified.
Object to leading.
All right, that'll be sustained.
If Dr. Feig testified that he didn't conduct that beta amyloid staining, would that be consistent with what you read?
Yeah, as I said, I didn't see anything in the first thing you do when you get a microscopic slide, you take the tissue, it's put in a wax paraffin block, and you cut little slices like 6 microns, very thin slices, and then you stain those. Routinely what we do, we stain.
That'll be overruled. You can
Go
continue.
ahead.
I'm sorry, I forgot where I was.
It's okay. You said that you didn't see any record of.
Okay, yeah, we normally stain, and the slides that I got were stained with the normal stain we do. It's a pink and blue stain called hematoxylin and niacin. And it gives basically the cells stain either pinkish or bluish. The nuclei of the cells usually are blue, the cytoplasm is pink. And on all our biopsies, that's the way pathologists read the biopsies. If we suspect something else, we would do a special stain, as I indicated before, if I was concerned, or if anyone was concerned that this was a diffuse axonal injury. It's provable by doing that special stain. That's all you got to do. And if you don't have it in your laboratory, you can send it. There's hundreds of labs around the country that do it. You just send the tissue out to them.
All right, that'll be sustained.
Okay, so what if you don't have the equipment in your laboratory to do that beta amyloid stain?
Well, that's what I mean. You send it out to the laboratories that do. Obviously, everybody can't afford to have all the stains in their laboratory. In my laboratory where I do the gastrointestinal biopsies, we don't have all the stains. And if we have something we need to do, we'll send it out to a reference lab and they'll do the stains and then we'll send us the slides and then we read the tissue.
Okay. And are there private labs around the country that do that sort of thing?
Well, that's what I just said. Yes, reference laboratories.
I apologize. So but did you testify that even without the stain, there would be some telltale signs of DAI?
Oh, yeah. I mean, that's what gives you the suspicion to do the stains in the first place. Plus the clinical history of the expanding subdural and rather than an expanding brain with no subdural certainly gives you indication that it's not a diffuse axonal injury. But yeah, under the microscope, you can actually see around.
The narrative and non-responsive.
All right, that'll be overruled.
Go ahead.
I thought you asked me about the stains, right? Okay. When you're looking at it, under the microscope, you can see around the blood vessels. Because the little vessels in the brain are injured too. So they'll lose, they can't keep the red cells inside because the walls are, so around the little vessels, you'll see the aggregated red blood cells. That's called perivascular or around vessel hemorrhage. And that's very characteristic in a diffuse axonal injury case. And when you see that, that gives you a tip off. And there were none in this case. When I looked at them under the microscope, there were none. So I was not suspicious of that.
Okay. Why does it matter? What difference does it make if there was DAI?
Well, it makes a big difference because of in order to get DAI, you have to have a lot of trauma. You know, automobile accident cases is where this was first described. High velocity impact injury. And if you've got that, it pretty well rules out an accidental fall. Whereas subdural hematoma can occur from relatively innocuous falls. Certainly a large hematoma developing rapidly is going to probably you're going to have a greater chance of that with more impact injury, but you can get that from basically an accidental fall. So that is the importance of making that distinction.
Okay, so let me ask you though, when you say you can get
Can you help?
So this is what's been admitted into evidence as states 48, and you'll see this wing back recliner in the picture. Do you see that?
I see it, yes.
And if Olivia had fallen off of that recliner onto this laminate flooring, could that be the cause of a subdural hematoma?
Well, it could be, but it's a relatively minor fall. I would expect if it had, it probably would have caused a fairly minor subdural hematoma, if any. But I would suspect it was a more energy related fall than that.
Okay, and then And then, so somewhere between a fall off of a chair like that and an automobile accident is what we're talking about.
Object leading.
Right, that'd be overruled.
Correct.
Well, I think it would, yeah, I think it would be well far below the automobile accident slamming head type trauma. But it would be a little more significant injury than just falling off, unless it took for days for this thing to develop. And this subdural probably developed.
Sustained.
Okay. Did, let me ask you this, are these, the injuries that you saw, the fatal injuries, to Olivia, are they typically caused by what, I think you said moving head?
No, if you were impacting a stationary head, that would be the opposite of what we see. A stationary type impact basically transmits force right through the skull, from the scalp to the skull to the brain underneath it. So we don't have a moving head in that case. We've got a blow, and it's a totally different situation from what we see, which is this is a moving head injury.
So you're saying Olivia's injury is a moving head?
Oh, absolutely. That's how a subdural hematoma forms.
Okay. If showing you what's been admitted into evidence of stage 42, and I'm going to hand that to you so you can feel the weight of it. Do you believe an object like that swung with any amount of force could cause the injuries that Olivia suffered?
Well, not the subdural hematoma, certainly. That's a totally different. The child's got some scars on the head, which could be a fall, could be a blow, and we just can't tell, except they were minor injuries. So whatever was causing the scars on the scalp was not a significant amount of trauma because it didn't do any damage to the underlying brain.
To the brain.
To the brain.
Okay, but you believe this stage 42 could not have caused the subdural, the fatal injury?
No,
That'll be overruled.
no, it's a totally different mechanism of injury.
Okay. So when you reviewed the University Health Science Center records from the date from September 5th of 2017, do you recall seeing in there anything that you found significant?
Well, I reviewed the records because there were several issues in the autopsy report and the findings that were of concern. Overall, just on the surface of it, the reported injuries at the autopsy are very suspicious for child abuse. So the question is, it was what the medical examiner looking at, was that completely accurate, or was there something else going on? So there were two major areas that I needed to look at to decide, basically in my own mind, whether or not this was an abuse case or there was something else.
Okay, and what were the things that you found in the medical records that were significant?
Well, yeah, the issue I was concerned about was there were two issues. Number one, the bone, the changes in the bone of the distal humerus, and the laceration described in the pictures and described in the autopsy of the upper lip. Both of which, if they're actually present, are together with the other injuries, are going to be pretty diagnostic of non-accidental inflicted trauma. So one of the things as a medical examiner you want to do is you want to be sure you're right on those issues. So
Oh, okay. So let me put up states 178, and this is a cross section of the arm. Tell us what's significant about that picture.
well, this is the bone that the pathologist took for examination. And he also took sections of the area involved with the changes and took those microscopic, and those were the microscopic sections that I had to look at as well.
Okay. And what does this tell? What does 148?
But one of the
178 tell you?
Yeah, well, one of the problems is there is some reactive changes. Now, if this was an adult where the bone growth had stopped, it would be pretty suspicious for being a fracture. The problem with a 4-year-old is that the bones are still growing, and the bone growth occurs what we call the cartilaginous plate, the bone growth plate. That's how the bone gets longer. The cartilage keeps growing and growing, and the kid gets growing and growing. Well, in these changes, there can be really some, from a surgical pathologist standpoint, pretty scary changes that occur. And I was very uncertain, and it's well beyond my areas of expertise to look at the changes in a pediatric, because I don't do that rarely. It's not like I do when I'm doing gastric biopsies. I do that every day. So what I recommended, I believe I issued a report, was because this was a gray area, that those slides should be sent to an expert in pediatric bone pathology, so we could come to the conclusion, are these fractures or are these actual unnatural event? The bone scans, the skeletal survey done by the people that are looking for child abuse in the medical records showed that there were no suspicious lesions. Well, that right now concerned me, because that obviously they should have seen it if there was a fracture. This was on both sides, which means that it was occurring at the same time, both sides, which again, in a child abuse case would be highly unusual that you get all the fractures, only 2 fractures, and they're both exactly the same position, right and left in the same bone area. So it's suspicious for something else going on. So I recommended that they be sent to a specialist in bone pathology to be looked at. And as far as I know, I've not been provided with any report or any indication that that was done. So that could have definitely made the difference between, is this a fracture for sure, or is this a natural process for sure, which again would nail down the child abuse issue.
Okay, so what else? I mean, what else were you suspicious that it could have been?
Well, suspicious that it's just a normal growth, part of the growth pattern of child. I mean, the bones grow at different rates in different people, depending on their metabolic status, their genetic status. It's very complicated. You really need to have somebody that knows what they're talking about looking at these. And that's why you'd send it off to an expert that can really tell you this thing. I wouldn't pretend to try to make a diagnosis. As forensic pathologists, we do a lot of things, but we're not experts in everything. And this is an area where you need to send it off. And as far as I'm till today, I have not heard that that's been done or what those reports were.
And what type of expert would that?
A pediatric pathologist, which is another subspecialty like forensic and cardiac and neuropathology. Pediatrics are do specialized training after their basic training, and they become experts in looking at child pathology in children. And one of the things would be that somebody experienced in really looking at what these changes were, would be able to tell if this was reactive or traumatic. I can't tell, and I don't think most forensic pathologists can tell. And I don't like to just say, well, this is consistent with this or consistent with that, when we basically have a way we can tell for sure.
Sustained.
Okay. So did you also notice in the records from UHS anything regarding the scratches on Olivia's hands and feet?
I'm sorry, I'm losing your,
No,
you're
I'm
fading,
sorry.
you're fading. I know it's long,
I'm
late
home.
today, but
Did you notice anything regarding the scratches, the linear scratches on Olivia's hands and feet?
nothing particular, other than that there were some contusions, some scratches, and that would be consistent with, I had used consistent with, those would be indicative of a possible fall where she hit multiple areas and saw some scratches.
Okay, but did they say anything, did you notice anything in the UHS records about an explanation for that?
Well, about the bruises and the fractures, I think one of the pediatricians basically indicated that was consistent. Her areas of bruising and so forth were consistent with normal play for her age type thing, I think was the term they used.
Okay. And then let's talk about States Exhibit 121. I'll come up there in a second. I think, yeah, there we go. And that's the torn, is it pronounced frenulum?
Well, it's the frenulum is what it would be torn, but this is not exactly a torn frenulum. This is basically a laceration in the mucosa of the lip going down into the area where the tooth is missing and that adjacent tooth.
Okay, and did you notice anything about that in the medical records?
Well, this is a big area of concern because one of the things you look for in child abuse cases is multiple trauma. And this is an area that's frequently traumatized in child abuse. And one of the things I was concerned about in this case was that although you see that superficial laceration cut of the mucosa, you don't see any bruising and swelling around the area that would indicate a blow. In other words, when you get a blow, you get all the soft tissue and everything also. So I was concerned about that. So I went back to the medical records and the admission physician and a secondary consulting physician, I think in the intensive care unit, both describe no trauma in the oral cavity. Now they're looking right at the area. Two doctors looking at the area in the medical records. They describe the other changes that occurred, the bruises, the scratches, the hemorrhage around the eyes and so forth, but do not indicate any trauma to the lip area. Well, remember I talked about iatrogenic injuries. Well, this is what my concern was. Well, if the doctors, when she first came in, didn't see that, which is pretty obvious, then my major concern is that this is an iatrogenic injury that occurred after not one, but two doctors look at the area and don't see any trauma. Now, when a patient is intubated, one of the things that can happen, first of all, if it's a difficult intubation, you got to understand that this is not a question of improper anything, but just in the handling of an emergent child intubation or an adult intubation. You can see these areas of trauma in a normal intubation if it's a problem. So what you want to do is you want to rule that out. In this case, we were able to rule it out by the fact that the two doctors did not see it when they examined her when she first came in. Now, when the intubation tube is placed in, you have to keep it in place. So basically they're strapped down and so forth. And
That will be overruled.
Go ahead.
well, you can see from the photos of the child that this was strapped down and taped. So I'm not speculating, I'm looking at the photos, that this was taped over by adhesive tape, and
I'm
that's to
sorry,
keep the
doctor,
tube in
did you say
place.
that's speculating?
Pardon me?
Did you say that's speculating?
No, I said I'm not.
Okay, all right, thank you.
Not speculating.
All right, thank
I'm
you.
looking at the picture. Right there. You can see all this going on. It's a very blurry picture. Back it out a little bit. You're in too close. We've lost the pixels here. Keep going, back. You can see it. All right, see, you got tubes coming in here. You've got all this tape. You've got a tube right over. That tube's coming in right over. Actually, if you go back to that other picture, see how linear that looks?
Sorry. me one second.
You haven't lost it already, have you?
Yeah, there we go. Right underneath.
Okay. So don't let the attorneys play with the, all right, see how linear that is? That would be very consistent with a tube coming over and pressing, and once that taped down, that's what's going on. But the critical thing is it was not there when two doctors looked at the child when it came into the admission.
That will be overruled.
You're basing that on the medical.
The medical records, yes, we just went through.
All right, and excuse me, doctor, I'm sorry, but if you could stop beating on the desk, because it's,
Oh, I'm
we're
sorry.
getting feedback. That's okay.
You got great.
All right, thank you.
Okay.
So showing you
Just giving
page
you away.
48, it's numbered down at the bottom here, page 48 of 388 of States Exhibit 18. Is there anything, any reference to them looking at the mouth?
Well, yeah, nasal bridge are coming out. Tooth E is missing, which means that upper tooth. They gotta be looking right at it. And then unable to assess the inside of the mouth essentially because she's intubated. But he's looking right at that area and does not see any trauma. And certainly a pediatric trauma person suspecting child abuse is not going, and two of them are not going to miss a laceration of that size in the upper lip.
Okay, and then there are other references in the record, is that right?
Yeah, I found at least two people that examined.
Okay, and looking at page, sorry, 232 of 388 of the same exhibit.
Up a little higher. Yeah.
Higher, did you say?
Yeah. Oh, go this way. Yeah. Okay, good. Perk, stop. The swelling over the bridge, periorbital. So they're doing it. And again, a very thorough exam, looking at all the ecchymoses and so forth, but not seeing that laceration. So it'd be impossible to miss, in my opinion, if it were there. So it was there after the tube had been secured.
Right.
Testifying as to what other people.
Judge,
All right, that, with regards to what other people observed, that objection will be sustained.
okay. Are you testifying to what you read in the medical record?
Right. That's the only information I've got. I didn't talk to anybody or wasn't there at the time.
Okay, and I'm looking at page now, they're showing you page 239 of 388. Was there also something in there that caught your
Yeah,
eye?
read here, head, mouth, atraumatic, which means they looked at the mouth and there was no trauma.
Okay.
So that's three doctors.
Okay, so, and did they look close enough to see the missing tooth, which is right next to them?
Yeah, they would have to have. And plus, that would have been what they were looking for. They would have been looking for oral trauma.
Because is this the Center for Miracles doctors that are doing this, the people who are looking for child abuse?
Well, yeah, I guess so, yes.
Okay,
Well, any doctor is going to be looking for child abuse in a case of like this.
okay. And that brings up another topic about mandated reporters. Do you know what mandated reporters are?
That's relevant.
That would be overruled.
I'm not con with that term,
Child abuse reporters, are you familiar with that?
mandated.
Mandated child abuse reporters.
Well, yeah, any doctor has got to report a suspected child abuse case.
Okay, and if you know, is it a crime to fail to report that?
Oh, I don't know about Texas. In Florida, I don't know it's the crime. You probably would be, your license would probably be in some jeopardy if you didn't report suspected. You don't have to make the diagnosis, but you should report a suspected child abuse.
Okay, and then put these back in order. Do that. And then let's talk about You said that what you classified as a simple fall, like, for example, off that chair, probably would not be enough.
No, I think it would be more, it would take more energy than that.
Okay, and I'm showing you what's been marked and entered into evidence as defendants 5, 6, and 8. These are stairs that are outside of Olivia's apartment. And there are two different, there's a set of 6, there's a set of 8, and then there's a set of 12. Would a fall down concrete stairs like that with a steel bullnose be sufficient to cause the fatal injuries that you saw?
Well, it would create a lot more energy because obviously that if you're falling down the stairs, you're going to be a lot higher than just fall off a chair. That's going to be going down. So you're going to have enough energy. But yeah, that probably would be enough. Probably not all the way down the stairs, even just probably a couple of steps.
Even if you just fell down a couple of steps?
Yeah.
Okay. And but let me ask you this, because if that happened, it happened at like 10:30 in the morning.
Judge, again, I'm gonna object to defense counsel testimony.
That will be sustained.
Okay. I want you to suppose with me as an expert witness, I want you to answer a hypothetical. If the facts were that a fall down a set of stairs, much like that set of stairs, or down any part of those stairs, happened at about 10:30 in the morning, and then there was some imaging from later in the day around 1:30 that showed that there was a lack of that there was swelling causing a lack of differentiation between the white and the gray matter in the brain. The question, I guess, and if Dr. Gebhardt testified that that would take 6 to 8 hours to happen, would you agree? Is that an accurate assessment?
No, subdural hematomas can cause death within a period of minutes, depending upon how severe it is, how fast the bleeding is occurring. I've done many homicide cases where somebody in a fight is knocked to the ground and is dead in 20, 25 minutes or less, and I have no problem prosecuting that as a homicide case. One of the issues is, and one of the things I actually think that we went through in my textbook was that, remember, the clinicians are looking at cases that get into the hospital. Cases like the guy that's killed, dead on the bar room floor in 20 minutes, he's never going to get up to the intensive care unit. He's going to go right to the medical examiner's office. So there's a whole population out there that clinicians are never seeing because they don't make it to the hospital. But we have many cases where subdural, I'm sure that been prosecuted cases in this jurisdiction where subdural hematomas have been successfully prosecuted as homicides, even though it only took minutes for the victim to die after the trauma, and are very quickly, depending upon how fast the bleeding is occurring, that's going to be how fast the brain's going to get injured and shut down.
Okay, so is there anything about Olivia's injuries that would be inconsistent based on all the records that you've examined, the medical records, the autopsy record, all the photos, everything that you've seen? Is there anything that would be inconsistent with her having fallen down the stairs at 10:30 that morning, and I say that morning, the morning of September 5th of 2017 as the cause of her death?
No, I think that would be consistent with that happening from those injuries, from the acute injuries.
Okay, can you say for sure that that's what happened?
I don't think anybody can say for sure medically anything, but high probability that that's what happened. Everything matches. And if you take away the other findings, the bone that we don't know about, and clearly the injury to the lip, which is definitely not occurred before she went into the hospital, then it's more likely that it was a fall, but most likely not from a chair, but maybe down a flight of stairs or something to that degree.
Okay. All right, and then you said somebody in Dr. Gebhardt's position might only see the subdural hematomas coming after 6 or 8 hours because those are the people who make it to the hospital, right?
That'll be, I'm sorry.
Object to speculation as to what this other doctor observed or saw.
All right. If it's not based upon what you have read yourself in medical reports, then that will be sustained.
Okay, is it based upon your experience as both as a doctor and as a pathologist?
Yes, it's very difficult to get clinicians to come to even one autopsy, let alone come to autopsies for a number of years in the medical examiner's office. So they just don't see these cases that never make it to the hospital.
Do you see cases on a frequent basis or on a less frequent basis where I guess let me just ask that in a different way. How often do you see cases where people die of a subdural hematoma in less than 8 hours, 6 to 8 hours?
Well, many times, as I said, sometimes within minutes of, and particularly I think it's like barroom fights or assault or something that occurs all the time, but they never make it to the hospital. So the clinicians never see them. Medical examiners, however, we see them unfortunately a lot.
Okay, do you also see them from falls?
Oh, sure.
Okay, and
Anything that gets the head moving, a knock to the floor, falls from bar stools, whatever. And that's one of the things you have to make sure it's not an accident versus a homicide. So you look for other factors.
okay, and you said because what the examples that you're giving appear to be what do you call it? Either intentional or a result of a fight or something. But what I'm asking is, if somebody fell downstairs, do you see those where people?
Oh, sure. Yeah. I mean, the majority of the times it is accidental falls, but it can occur within a very few minutes.
Okay. Was there anything else that you found significant about any of the records that you examined or any of the documents?
I think we've about covered it.
Okay. Pass witness.
State.
Good afternoon, Dr. Anderson.
Good afternoon.
Defense mentioned that you were getting paid for your testimony and your involvement in this case. Can you just tell us what your fee schedule is?
Well, as I indicate, I'm getting reimbursed by the court for my time. And I charge $350 an hour for review and $500 for testimony per hour.
So how much time have you spent in this case already?
Probably in this case, probably about 12 hours review. And of course, I'm here in court.
So we're talking thousands of dollars?
Well, $350 an hour, yeah, you can do the math.
And it's fair to say defense likely wouldn't call you if your testimony wasn't going to be favorable to you.
Object to speculation. He doesn't know what I would
Is
do.
that correct?
All right, that'll be sustained.
You gave defense a report with regard to your review of this case. Have you reviewed anything in addition to what you reviewed at that time?
Well, in the report was issued quite a while ago, but yeah, I reviewed the records. I reviewed more records and so forth. Yeah.
What additional, I believe in your report, you said you looked at the autopsy and the photos, the slides, medical records from University Hospital, EMS records. What additional information relating to this case? Did you review?
Well, no other records, but I've gone back over those same records.
And you said you worked as a medical examiner about 20 years ago?
I think the last time I did forensic pathology as a medical examiner was in 2002. And then I was asked to cover for a medical examiner in Daytona Beach area in Florida in 2006. And that's probably the last time I've done any when I was working for the county. I do forensic autopsies all the time, second autopsies on cases and individual autopsies.
In your practice, primarily focused on gastroenterology now?
Well, as I indicated, but I also do private autopsies. I'm doing probably about 50 autopsies a year, plus 50 plus, and then I do reading the biopsies and so forth for the gastroenterology.
When you left the medical examiner's office in 2002, why was that?
I'm sorry, I'm losing you. You're,
When you left the medical examiner's office in 2002, why was that?
well, I resigned.
Were you asked to resign or did you?
No.
resign?
I was not asked to resign. I was asked, however, by the medical examiner at the time, the chief medical examiner, to alter a diagnosis on an autopsy case, which was a jail death case where the medication had been withheld from the patient. And the medical examiner's office in the county suggested that since they were being sued, that I should change the diagnosis. And since, among other things, that would be illegal in the state of Florida, I decided that I would have a better opportunities elsewhere. So I actually went with another medical examiner's office. And then subsequently, the medical examiners in Orlando, the guy that asked me to change the diagnosis, was removed by the state board of medical examiners from his position. And I've never had anything against my license or anything else. So.
But you also had your private business going during this time as well.
Well, in Florida, we were allowed to do that. You could have a private practice in Florida under the medical examiner statute. It was in the statute. You can do private work as well as the medical examiner's office as long as there was no conflict. And all the pathologists did that. There was no problem.
The non-responsive and narrative.
All right, that'll be sustained.
So you said that never created a conflict for you, is
No.
that correct?
Correct.
So your resignation didn't have anything to do with an internal investigation going on by the county?
Well, the county launched a quote investigation.
Judge,
No.
he's entitled to explain his answer.
All right, Dr.
No.
Anderson, if you'll listen to the question and just answer the question that's asked.
Now, when you were working as a medical examiner, aside from the body itself, what type of information would you rely on in doing your autopsy?
Well, it would depend. Always as a scientist, you have to look at hard data. Where it's not what somebody thought happened or the police thought happened, or you look at the actual data. You look at what you see in the autopsy, what you see in the microscope, what you do in the toxicology, what the medical records have documented, and so forth. But you don't get down the rabbit hole of saying, well, this person said this and this person said that. I don't think I ever prosecuted a child abuse case where the person didn't say that this was an accident. I mean, they always do that. But you as a medical examiner, you've got to prove one way or another what that is. And that's what I did as a medical examiner. And that's what I did when I worked up this case.
The perpetrator usually said it was an accident.
Almost always, yes.
And you said hard data, what's in the medical records? And where are you currently living?
I'm sorry.
Where do you currently live?
In Orlando area, Florida.
Relevance, Judge.
That'll be overruled.
How many forensic pathologists are there between here and Orlando?
Object to relevance. Judge.
Between here and
That'll be
geographically,
overruled.
I have no idea.
Why did defense have to go all the way to Orlando to hire you?
Object to relevance. Object to
That'll be
speculation.
sustained.
Well, actually, an internet,
Excuse me.
I'm sorry.
All right, when either side raises an objection, stop speaking.
Oh, I thought
And
she was through.
well, just one second. And what I'll do is I'll make a ruling and then I will let you know whether or not you can continue or not. So,
Fair enough. Okay.
all right, State, ask your next question.
Now, we already talked about what you reviewed in making your report. Are there any changes you would make to your report?
No, I essentially was very suspicious of child abuse initially in this case. And that's why I went through a fairly extensive process of trying to prove one way or another what this was.
And did you ever review the scans and imaging in this case, the CT scans or the
Just the reports.
So no.
No, I only reviewed the reports. I would leave up to the expert radiologists, so forth, to read the, but it seemed that there were a fairly competent group of people reading the x-rays and so forth.
And you weren't involved in the initial autopsy in any way.
Correct.
And defense asked about redoing the autopsy. You haven't redone any sort of autopsy.
I'm sorry.
You have not redone any sort of autopsy. I just want to make clear for the jury that you have not redone any sort of autopsy in this case, because that's what defense asked.
On this case, yes, no. I do second autopsies all the time, but not in this case.
And you weren't involved in this case at all prior to that.
Till what year?
I'll move on. So as you stated, your work is based solely on reviewing the reports of others, photographs taken by others. Did you talk to any doctors involved in the case?
No,
Did you talk to any witnesses involved in the case?
no, I never talked to witnesses.
Did you talk to any of the other expert witnesses involved in this case?
No, I do not review. As a scientist, I want to do a completely detached, objective view. So I don't look at depots. I don't look at anything like that. Now, I do look at records that have been documented records. Obviously, we do that, but no opinions otherwise.
Well, in doing that sort of thorough review, don't you think it would be important to look at the scans and imaging that are done?
No, I'm not a radiologist. I would not read the report. I would not read the films.
Don't you think that the doctors and other expert witnesses involved in this case would be better at interpreting what they noticed and what they saw and what they documented rather than you just reviewing it?
Well, it depends on what you mean. Are the doctors, are you talking about radiologists interpreting the radiology report? Or are you talking about clinicians interpreting the radiology? Because the radiologist, as like the pathologist, we issue report, we're experts in those areas and we issue those reports. And that's what I looked at. What somebody else thought again would be, that's fine, their opinions. But what I wanted to look at was the actual x-ray reports. For instance, the bone scan showed no evidence of fractures.
The narrative.
All right, that'll be overruled. State, you can ask your next question.
All right. So when Dr. Gebhardt testified that he believed this to be a diffuse axonal injury, and he reviewed the scans in the case, you're saying you'd be in a better position than him to say what actually.
No, is he a radiologist?
I'm asking the question here.
Well, if he's a radiologist, yes, but if he's a clinician, no. To read other than the report of the radiologist and make an interpretation if you're not a radiologist.
Judge, I'm going to object to the non-response.
All right, that will be sustained.
All right, Dr. Anderson, I want to go through some of your report.
Can you talk into the microphone? Because you keep talking into the computer and it's difficult to hear you. I don't want to miss it. I don't want to miss a question.
Well. Okay. You said in your report that you believe the causation of the subdural bleeding was most likely secondary to the child's head impacting an object such as the floor or a wall. And it correlates well with the finding of a recent subgaleal hematoma on the left occipital area. Do you still stand by that?
Yeah, and be consistent with hitting the wall, hitting stairs, as defense counsel asked me, would be one of the possibilities.
And you said the most probable scenario, in my opinion, was that the child was slapped with enough force to be knocked down or against some object, thereby a moving head injury. Do you still stand by that?
Yeah, well, I was very concerned that that was the most likely cause. And that's why it was necessary to go through the whole process of ruling that out.
But you didn't rule that out. That's what you said you believe was the most likely scenario.
Well, the most likely, yeah, the pathologist is going to come up. That was the most likely scenario. But whether or not that was the actual scenario, that's what needs to be proven or disproven. And that's basically what we did.
Sustained.
Have you been slapped before?
I'm sorry.
Have you been slapped before? Has
I-
anyone slapped you before?
Not lately, but I imagine my wife has some time or two.
What did you feel? What sensation did you have when you were slapped?
Well, there's this tingling of, most people have been slapped, I think. There's a tingling, hopefully not too hard.
Or characterize that as pain?
Object to the relevance, Judge.
Well, it might be painful.
Overruled.
Could we approach?
The objection is overruled.
Could we approach?
Ask your next question.
Have you ever been slapped with enough force to be thrown into an object?
No,
And you would agree that a slap is an intentional act, right?
correct.
Slapping you? Okay. And if they slap you with enough force to throw you into an object, it would appear that they're trying to hurt you. Would that be correct?
Well, if that were the case, if that had actually occurred.
Now you go on in your report to say that the findings of a contusion injury to the facial area in conjunction with a recent laceration on the inner aspect of the upper lip, along with the above detailed occipital area injury, represents an injury pattern frequently seen wherein a blow to the face results in an individual being propelled against an object and mitigates against it being a simple accidental fall.
Yes, exactly. And that is precisely what the problem was with the fact that you had the laceration and the injury. And that was why it was critical to find out whether that laceration occurred before the intubation or afterwards. And I think we've pretty well shown it.
Okay.
All right, that'll be overruled.
Aside from the laceration, the contusion that you saw, would that be the contusion to the bridge of the nose?
Yes,
Okay. And then would a strike to the face also be consistent with, I didn't see you talk about this, but the right subperiosteal hematoma on the victim's face?
no, actually, that's a different mechanism.
Well, what mechanism would cause that?
Okay, when a moving head strikes, if it's a sufficient amount of force, you can actually get skull fractures. And in the basilar skull fracture, then you can get what's called raccoon eyes, which frequently occurs when somebody has a skull fracture. If it's less than actually fracturing the large bones of the skull with a fall, you can also get the force transmitted can cause little bones around the nasal area to actually begin to bleed. And that's why you see around the bridge of the nose and over here. Now, if this were a punch, you would see on the surface, you'd see bruises here, here, here. But this is basically all that is missed. So this is a very classic example of moving head striking and the force causing what we call periorbital hematoma formation in the small bones. And if that goes on long enough, you get what's usually referred to as raccoon eyes, which you get, and that's from basically from a skull fracture.
Okay, yes or no, that would not explain the bruise on the bridge of Olivia's nose.
I just did.
No, you didn't. We're talking about the
Objection,
subperiosteal-
argument, objection, Judge, argumentative and counsel says.
Sustained.
You're talking, I asked about the subperiosteal hematoma by her eye, not the contusion on the bridge of her nose.
It's one and the same. It's the part of all the little nasal bones go from here all the way over, and the blood then seeps into the area around the nose, around the eyes, and so forth. And if you've ever seen somebody with a subdural hematoma from a skull fracture, you'll see that the whole area is involved, the nose, because it's all the same. It's all part of the same vasculature.
So if a witness in the case said she saw a bruise on the victim's or a black eye on the victim's face on Saturday, would that still be your testimony?
I would want to know if the witness was medically qualified to diagnose this or not.
Okay. So speaking about the medical records, Are you aware that Dr. Feig described the frenulum as being basically obliterated?
I'm sorry, described.
The frenulum tear, that the frenulum was basically obliterated.
Well, I don't know when that was described. All I do know is that we have the original initial doctors looking at that area and they didn't see anything.
All right, so if the medical records show that Olivia arrived at the hospital at 1:01, and you talk about a thorough exam, a fast exam was performed at 1:05, and then she's intubated at 1:11, don't you think the doctors there might have been more concerned about getting her to breathe and trying to save her life than looking inside her mouth?
Well, they did look inside the mouth though. The guy describes the tooth missing. So he's got, if you see the tooth missing, you've got to be looking at that area because that's where the hemorrhage is. So you can't be looking at the tooth and miss the rest of the,
But there were actually 2 teeth missing from Olivia, is that correct?
well, I don't know, but the fact the guys could see, the point was the doctor could,
You've seen all the photos, right?
well, none were missing acutely.
But she's missing 2 teeth, not just 1.
Okay.
Okay, and they weren't able to observe that the second tooth was missing.
Well, but if you're able to see the one tooth that's missing that he's describing is right next to the hemorrhage. In fact, there's hemorrhage around the tooth that's missing. So you would see that if you were able to see the tooth, you'd be able to see the laceration. And 2 doctors, or at least 3 doctors, didn't describe any trauma to the mouth.
If you're able to see 1 tooth missing, wouldn't you think you'd be able to see the other 2?
Well, it might be irrelevant. It's irrelevant the number of teeth that are missing. The fact is you're able to look at that area and when you look at the area, you don't see the laceration.
It's relevant that a 4-year-old child has 2 teeth missing?
No, I'm not a pediatrician. But the children lose teeth isn't my recall. My daughter lost 2 teeth around 4 or 5.
Do they lose them around 2 years old?
He just testified.
I don't know. I'm not a pediatrician. It would depend on the child.
Thereafter testified when his daughter's kids. lose
All right,
their
that will be, the objection is overruled.
Do they normally lose their teeth at 2 years old?
I don't know. I don't recall when they start losing their teeth.
So your testimony is maybe they start losing their teeth at 2 years old.
Well, we were talking about the injury particularly.
And defense asked you about the Center for Miracles doctors not noticing the frenulum. Are you aware those are the same doctors that said Olivia had sustained severe abuse, life-threatening physical abuse in the form of blunt force head trauma?
Well, that was their opinions. And that was one of the reasons I was suspicious of it too. But one of the things the medical examiner has to do in these cases is not necessarily just go along with what the clinicians feel, but look at the actual data.
But again, you weren't the medical examiner, is that right?
Pardon me?
You weren't the medical examiner in this case, is that right?
Well, no, I was not the medical examiner in this case.
And the medical examiner determined that it was a homicide.
Well, that's their determination. I would not, under the circumstances, unless the bone studies showed that there were.
All right, that'll be overruled.
Well, what did you just ask? I'm sorry, I just understood you said the medical exam was a homicide.
Yes, I was asking what the medical examiner.
Yes, that's what they called it.
And again, you didn't review the same evidence that the medical examiner reviewed.
Well, I reviewed the evidence that I had available from the medical examiner who documented everything.
Moving on in your report, you talk about autopsy and there being multiple areas of healing laceration type injury that appear to be multiple ages preceding the acute traumatic episode by a number of days or weeks, and that those were the result of blunt force impact and their number and multi-directional distribution were strongly suggestive of non-accidental inflicted injury.
That's true. Yes.
And you still feel that way, is that correct?
It's consistent with that. It's consistent with multiple impacts, not necessarily inflicted, but the child could have fallen and so forth, but it's very suspicious.
Okay, so a child would fall directly on the top of their head?
I said it's very suspicious.
I mean, a child would have to like dive into a pool of knives or something to sustain injury.
Well, we can't assume that they all occurred at the same time. They could have occurred over a period of 4 years. Child was 4 years old. So
When you say they're very suspicious, what do you mean by very suspicious? Very suspicious, what?
well, again, the whole case is very suspicious for child abuse until you begin to sort out some of the factors that suddenly make it less suspicious.
You say strongly suggestive of non-accidental inflicted injury.
It is. On the surface, it is.
And you say that these scars appear to precede the acute traumatic episode by a number of days or weeks. So we're not talking years, we're talking days and weeks, at least according to your report.
Well, I should probably amend that to say, well, once a scar is formed, it's there. So it wouldn't necessarily be, some of them were healing though, which would indicate that they were recent, days or weeks.
And you've spoken a lot about diffuse axonal injuries. And the lab tests that would need to be done to detect those. And they weren't done in this case. Is that correct?
They were done?
The amyloid testing that you described
Yes,
was not done in this case.
correct. As far as I know, but not.
And there was no MRI done in this case.
I'd have to review to see if there was or not. But the pathology diagnosis, looking at the tissue, is the gold standard, whatever the MRI or not. But you can actually prove one way or another whether this is diffuse axonal injury by doing those stains.
And if the medical examiner testified that he couldn't tell and he didn't do those stains, are you saying that this is 100% not a diffuse axonal injury?
Well, you have not done the studies you need to make that determination.
So you can't say that it's not. Is that correct?
From what I see under the microscope with the
Objection,
tissue,
burden shifting, Judge. They're asking if the defense can prove that, that it wasn't diffuse axonal injury. We're not
Right.
required to prove anything.
That objection would be overruled. This is cross-examination.
And isn't it true that marker of diffuse axonal injury itself is the subdural hematoma?
well, as I indicated before, no, not an expanding subdural hematoma. With diffuse axonal injury and the brain swelling, you do get subdural hematoma accumulation, but the brain swells quickly enough that it basically causes a tamponade or the bleeding to stop. So you get a very small subdural. In this case, we have an expanding subdural hematoma, which means that the brain was not swelling that fast. So if you're concerned about whether or not this is a diffuse axonal injury, that's why you do the special staining. So you can say one way or another.
Okay. So based on what you're just saying, defense asked you this theory about this stairway and this injury occurring at 10:30 a.m. and Olivia basically being brought in brain dead at 12 noon. You're saying this wasn't that type of injury. This was a slowly expanding injury.
No, I did not say it was slow. I said it was a subdural. And I also said subdurals can be very rapid bleeding, but it's a subdural and it does not, the brain was not swelling itself. What was causing the brain was the swelling, the bleeding, which was then causing intracranial pressure increase.
Direct examination, when defense asked you the difference between subdural hematoma and diffuse axonal injury, you said subdurals were slow. Diffuse axonal injury, those were much more severe. They expanded a lot more rapidly. Did you not say
Judge,
that?
that's a mischaracterization of his testimony.
All right, you can answer the question.
No, what I said was that the brain swells rapidly in a diffuse axonal injury. Now, for the third time, the tamponades and stops the subdural from forming. In this case, we have the subdural forming, causing the increased intracranial pressure because the blood is now coming into a closed container, if you will, the inside of the skull.
You also talk about the autopsy notating the presence of a healing fracture in the left humerus. And you say the radiology skeletal survey was reported as showing no suspicious osseous lesions, but that's not exactly correct, is it?
The radiology, the skeletal survey showed some bilateral humeral calcifications in the soft tissue, which is not a healing fracture by radiology. The radiology said there were no fractures. And my point earlier was that looking at that under the microscope, it is difficult for me as a non-pediatric bone specialist to make that diagnosis. I also put in the report that those should be referred to an expert for that evaluation to be confirmed or one way or another, whether it's a fracture or not a fracture.
When really what the radiology report says is that the left distal humerus is concerning for sequelae of prior injury. And then it says soft tissue calcifications along the bilateral humeral diaphysis favoring myositis ossificans from prior injury.
Correct. And it's suspicious. It was suspicious and it is suspicious. That's why you need to send it away to somebody who can tell you the answer.
Your report says no suspicious osseous lesions. Is that correct?
No, I didn't think I don't understand your question.
Your report, what you're now saying that they were suspicious, but you said the skeletal survey said no fractures of suspicious osseous lesions.
Yeah, that's what the report said.
Sorry, Judge, for clarification, do you mean that's what your report said or that's what the?
No, that's what the radiology report says.
And Judge, I'm just objective. I haven't passed the witness yet.
All right. Everyone, wait till she passes the witness defense.
Yeah, Sean.
Now, defense asked about the collapsed lung and that possibly being caused by medical intervention. Have you watched any of the interviews in this case?
No,
Do you know anything about the back history or any statements that were made or the history given about how Olivia ended up in this position?
no, I believe I'm just looking at the basic facts that we have, the hard data we have in the case.
So would it surprise you that there's no evidence, any interviews, any statements taken, any body camera footage, anything whatsoever about a child falling down the stairs?
It wouldn't surprise me. Frequently, accidents occur when the caretaker doesn't know about it.
That's not responsive.
No, you asked me, would be
That'll be overruled.
Okay, so your testimony is based on defense's question that it's possible this child fell down the stairs, obtained a rapidly expanding subdural hematoma, enough so that she's basically brain dead by the time she arrives at the hospital. And you're saying that she'd be able to fall down those stairs, get back up, shut the door behind her, get back in bed and find herself in the exact same position where her mom left her 15 minutes earlier?
It would depend again upon how rapidly the subdural, but in subdural hematomas, a very classical clinical situation is that there's a lucid, in what we call a lucid interval between the time of the trauma until the brain swelling has gotten bad enough to create neurological problems. And that can be minutes, can be hours, can be days sometimes. But in this particular case, most likely it could have been a few minutes.
You also said in your report, again, the most likely scenario, in your opinion, was that this child was not with enough force to be knocked down or against some object.
That's an answer, Judge.
Sustained.
Isn't it also possible that she was struck in the face with an object or struck in the face enough to throw her against another object?
Well, we don't have injury. We don't have injuries of the face. That was the whole reason for excluding whether or not that trauma was to the lips was actually due to a blow.
That's 6. Okay, so you said no injuries to the face. Again, I know you haven't had a chance to look at these scans. But on the area where Olivia has that bruise, her nose is curved to the side, wouldn't you agree?
I would have to defer to the radiologist to, because so much can depend on the angulation as the person goes through the CT scan or deviated septum. Certainly doesn't look like there's any soft tissue hemorrhage around there, like a broken nose or anything.
And I don't know where the other picture is, but the best picture to say it. You're saying that this isn't a bruise right across the front of her nose.
Well, I think we've already described that. No, this is periorbital. You can see the brown here, and across the bridge of nose. Can you see? Well, you're not showing up on there.
Dr. Anderson, what other, you talked about injuries suspicious of child abuse. What other injuries do you look at that may be suspicious of child abuse?
Well, basically, initially I was suspicious because of all the things we went through. And I ruled those out as best as I can by the studies that we either should have done or were done, and the review of the medical records. Particularly the lip injury is pretty characteristic of child abuse if it's there. And the fact that it's not there at the first time the child's admitted is a major factor.
Again, you're basing that on your review of the records. So I mean, when you actually.
Well, yeah, but the doctors have looked and they didn't see anything.
What about bilateral scarring or injuries to the ears? Would that be suspicious of child abuse to you?
Well, actually, those type of injuries are not particularly what you usually see in child abuse. If the ears are tugged, you see behind the ears, you see stretching of the skin and hemorrhage behind the ears. This is more or less scratching or something just like that area. But that's not the typical child abuse injury. And we do look for that all the time to see if the ears are pulled and the basically stretching injury occurs in the ear.
gave a statement saying that she pulled the victim's ears. Is that what you're saying is child abuse now?
Not necessarily, it depends on the force that's being used. And usually in a child abuse case, if they're pulling the ears in anger, there's enough torsion on the ears to cause actually behind the ears, the skin being pulled away and hemorrhage behind the ears.
But again, you're not a child abuse pediatrician.
I'm sorry,
You're not a child abuse pediatrician.
I'm losing your last word.
You're not a child abuse pediatrician.
No, I'm a forensic pathologist, and we deal with child abuse from the standpoint of doing a scientific analysis on the alleged victim.
And if the child abuse pediatricians involved from the Center for Miracles found that this child sustained life-threatening child abuse, they would be in a better position to testify regarding actual child abuse.
Not necessarily. It depends on what you, did the child abuse expert, for instance, know that the first admission and examination didn't show any trauma to the lip area, then he sees the lip area and assumes that's part of it, or the fracture not being documented one way or another.
All right, that'll be overruled.
Did you have Olivia's prior hospital records in your review?
I was made aware of some of them, but I did not look at those specifically. I was looking specifically at what dealing with the actual incident that occurred that caused it.
All right, so I'm showing you Olivia's growth. We see at 2 years old, she weighs 12.3 kilograms. And then when she passes away at 4 years old, she weighs 12 kilograms. Would that be concerning to you?
The fact that she hasn't gained weight might or might not. As a pathologist,
Okay.
I would defer
The
to.
fact that this child has lost weight from the time she's 2 years old may not cause you any concern, is what you're saying.
No, as a pathologist, I would be concerned about some metabolic problem. I would defer to the clinicians as to what clinically this meant, whether this was a small child or whatever. The clinicians know better. A pediatrician would know better than I.
And if the clinician said she had no underlying conditions that would have contributed to her condition, you don't have any reason to dispute that, yes or no?
Well, right. As a pathologist, I don't know that that was necessarily reflects the pathological condition. It could have just been her normal state.
So defense asked you if this absolutely could not have been the weapon caused Olivia's injuries.
It could not.
Okay,
This was not a direct force injury.
all right. Well, what if she's struck with this enough to throw her into another object?
Well, we should see if that was the case, we would see an acute laceration caused by that. That implement would have caused an acute laceration of the scalp or the head if she'd been hit by it.
You would agree with me, though, this side of the object is a flat surface.
Yeah, but it would create, you'd have to have some evidence that that was the case.
And your testimony is that this area to her face is not a bruise, despite other witnesses testifying that yes, that's what it was.
Well, correct. That is caused by the bleeding, the periorbital bleeding.
Have you read any studies about stairway falls in children?
I don't specifically as far as falling on the stairs. No, I don't know any studies specific.
No, you haven't. Are you aware that the literature shares says that that is a very rare occurrence?
Object to counsel testifying. Judge.
Judge, I'm
That's overruled.
I don't know how, what would be considered rare.
like a 1 in 2 million chance of dying from a stairway fall in a child. Would
Well,
you consider that rare?
I would like to know where they got their information. I've seen cases where kids have fallen downstairs and died. I would like to know what data they were basing that report on.
Basing them on studies done that relied upon in child abuse pediatrics.
Well, now, are we talking about ones that get to the hospital or medical? As I said, there are many cases that never get to the hospital. So if they're basing it just on the clinical findings, it might be totally skewed. You might have, if 90% of the kids die immediately falling down the stairs, they'd be only looking at the 10% that made it to the hospital if that's what their study's based on. So you'd have to know what the data is that they are using.
Stair-related injuries to young children treated in U.S. emergency department.
Well, again, I haven't read that, but I want to know the data that that was based upon. If that's a clinician based on the people he sees, then they may be missing a great deal of people that never make it to the hospital to be in that cohort that they're using for their study. You'll be very careful about picking data points.
So you're saying that children who fall downstairs would die immediately?
No, of course, I'm not saying that. I'm saying you asked about the study. And I pointed out that the data that they're taking their study on is very important. And you've got to analyze that data. And I don't know what studies you're talking about, but I have not reviewed the data on those.
Well, Judge, they have to give them an opportunity to review the study. If they want them to review it, they should give it to them and let them
Judge,
review it.
again, I'm going to object.
All right, could I have both parties approach? All right, everyone, we're going to take a brief break and we're going to come back at 4. So remember what I told you, because It's not 4 o'clock yet, so there are other people in the building. Make sure that you have your badges on. Do not discuss testimony amongst yourself. If you hear anyone speaking about anything, ignore it. No research. Everything you need to know will be from inside this court. And I know that I said we will be leaving today at 4:30, but I want to just make sure that we finish with this witness. Is everyone okay with that? Yes. All right, everyone, please rise for the jurors.
All right, and do you all have any problem with me letting the jurors know that tomorrow there are videos to watch to see if they're able to stay late?
That's fine with me, Judge. Do you think it'll be late?
Well, I mean, you're saying one is 5 hours, one is 30 minutes. I don't know how long that's gonna go. They have to have a break for lunch.
Yeah, you're right, because we've been just from my time log. So, yeah, no, I have a problem.
Okay, all right, thank you. All right, yes, you can bring them.
All right, to the jury.
All right, everyone, please be seated.
All right, state, it's still your cross.
Dr. Anderson, am I understanding you correctly that you're saying what Dr. Fye documented as a contusion, a bruise on the bridge of the nose is not a bruise?
No, I believe that is due to the periorbital hematoma that's now seeping up into the skin. And the reason is, if this were direct trauma, you should have bruising to the bridge of the nose, the area up here and so forth. And it would be hard to get and plus you've got the periorbital hematoma.
That wasn't my question. You're saying that the contusion, which the person conducting the autopsy describes as a bruise, is not a bruise. And you're saying, even though it appears that she's struck on the right side, that her nose doesn't appear to be curved to you. in the
Object
middle.
to counsel testifying, Judge.
That'll be overruled.
That's what you're saying, yes or no?
Well, I don't believe it's a hematoma from a direct trauma. I believe it's a hematoma from the consequence of the periorbital hematoma and the blood seeping around the area. And that's why you've got this entire pattern of injuries.
But you don't have an interior pattern of Olivia's face. Is that correct?
I'm sorry, you don't have,
Where are the other hospital photos? You said you didn't review the history given for how Olivia ended up in that situation. Is that correct?
that's correct.
What are symptoms of a head injury?
It can be multitude of head, depending on how severe it is, where the trauma occurs, whether it's moving head versus impact. There's hundreds of different symptoms that can occur.
So if she told at least two different doctors, if the defendant told at least two different doctors that Olivia was vomiting at 10:30 before she left and she didn't check on her, vomiting is a symptom of a head injury. Is that correct?
It can be.
And that would have been prior to the period where Olivia's left alone. Is that correct?
Well, if the vomiting were due to the head injury or the vomiting could have preceded the head injury. I mean, that's why when it's a forensic pathologist, you don't necessarily, unless you've got documented history, you don't necessarily, because people get confused about times, they are inaccurate in their memories. That's why we just look at the hard data.
So if you were a medical examiner, you didn't look at prior history, or you guys didn't have investigators that worked on your cases?
If it's documented, If it can be documented, yes, but just because somebody says something, no, I would not. If that contradicts the findings of the medical examiner, then you ignore the history. The findings are the findings. The science is the science.
So what was the history in this case that you reviewed?
Pardon me?
What was the history in this case that you reviewed?
I did not hear your question.
What was the history in this case that you reviewed?
What was in the medical records and documented at the time the child arrived in the emergency room.
And what was that? Do you remember?
Well, it was pages and pages, 50 some odd pages of documentation, which we highlighted some of it. But not the history that was given to the providers. That I did not necessarily take into consideration.
You don't think providing an accurate history is important when
Yeah.
you're giving medical care?
Of course it is, but you can't depend upon it. And that's why, as a forensic pathologist, you don't depend upon that. You depend upon what you actually see and observe and document and prove.
And you say you still stand by everything in your report.
I would say yes. I think we've read pretty much all of it, except for the bone part.
So in that case, you agree that Olivia was a victim of child abuse.
No, I think she was very suspicious for child abuse. The case is suspicious for child abuse. And that's why you need to be careful, very carefully rule out whether it is or is not. And we've been through that the last couple hours.
But you can rule it out.
Not completely.
And you said the most probable scenario is that she slapped with enough force to cause these brain injuries.
That is a possible scenario, a probable scenario.
Most probable scenario.
True, but falling down the steps would also be explain the injuries.
Most probable scenario is that she slapped with enough force to throw her into an object.
Yeah, and we read that about 6 times. Most probable, and most probable means you rule out or rule in by doing other studies and other analysis as we've been through. And that's how you come to this. I'm much less suspicious now than I was before.
And there's been no other information provided to you about any sort of stairway fall. There's been no evidence presented. Is that correct?
No, I believe the attorney
Ask you questions about a stairway.
gave me a hypothetical, yeah.
Yeah.
And asked if that would be consistent. So that's consistent.
Okay, but that's not evidence. Is that correct?
No, he showed me the stairway. I've got a picture. The picture of the stairway, that is evidence. He asked me if a child falling down those steps could create these injuries. My answer is yes.
You don't take the picture of a stairway taken 2 years later, but not the police reports, witness statements, the entire investigation. You don't think that's important?
Well, it may be important if it's accurate, but the problem is, as a forensic pathologist, I have been involved long enough in these cases that sometimes it's all inaccurate. That the history is based upon what they're being told, and that's not correct. And the suppositions are being made, and that's not correct. So what you do is you look at the hard data, the actual autopsy findings. That's what I did in this case.
What about the finding by Dr. Five, and he testified that it was the thickest he'd seen, the callus, basically, the subgaleal layer that was so thick because of all the head trauma Olivia had sustained.
Well, clearly there was evidence of multiple times where there was head lacerations of the scalp.
On the top of her head.
Yeah.
And you've seen the EMS reports, you've seen the records, you've seen where witnesses discussed about bruising all over her entire body, her arms being deformed, scars all over her body,
Yes.
all those things.
Yes.
And don't you think that's a bit more important than a picture of a stairway?
Well, we're looking at what caused the injury that we were talking about that caused her death.
But again, you don't have any evidence of a stairway. You have a picture taken by an attorney.
And we have no evidence of any other. We have no evidence of being traumatized. We have no pictures of that. But we have to take the findings that we have, and then we come up with what the possibilities are.
You don't think that Olivia Briones had been traumatized? Is that what you're trying to say?
No, I'm saying that it's consistent. her injuries, the cause of death, are consistent with her falling down the stairs or any number of other scenarios that could take place. And that's what the report said.
Sustained.
I'll pass the witness.
Defense.
Paid to say anything?
Pardon me?
Are you paid to say any particular?
No, of course not.
Okay.
In fact, I'm have to pay for coverage to be here, so
I'm sorry.
I have to pay for coverage for my practice to be here, so I'm breaking even.
So, I mean, you said it's consistent with a fall down. And by the way, you didn't even know there were stairs before this, right?
No, correct. You asked me if that would be a possibility, and yeah,
Okay. And now that you know that there are stairs, I mean, when you wrote the report, you didn't know anything about what this being a 3-story walk-up.
correct.
Just like Dr. Feig didn't know anything about, it, correct?
Well, I'm not sure what they knew or didn't know.
He didn't mention it in his autopsy, correct?
No,
Okay. But when he found out about it, he took new evidence
Judge,
into
I'm
account.
gonna object to defense counsel testifying and leading.
Sustained.
What do we do as scientists when we find new information?
well, we basically figure that into our opinions and our conclusions, and we either change the conclusions or it supports the facts or it does not support our conclusions. And if new evidence comes up, then the conclusions may change.
Okay, so, and new evidence to you is, oh, wait a minute, this is a 3rd-story walk-up, is that right?
Well, that's a possibility, sure.
Okay, so I guess what I'm asking, the state asked you about your statement that the most likely scenario, the most probable scenario was that this was a slap that led to, with enough force to be knocked down or against some hard object, thereby a moving head injury, right?
Correct.
Okay. Do you still find that to be consistent? Do you still find these facts to be consistent with that scenario?
Well, as I say, I ruled out several things that I had not included. I had initially thought that the trauma to the lip was related to the fall or to the trauma that ended up. And basically reviewing the records, I found that was not the case. We very clearly, the child did not have those, according to the medical records, 3 doctors did not have those when she came in. So that altered my opinion, obviously. So I was less suspicious of this being a child abuse case.
Okay, well, but what I'm asking is, have you ruled out that this was a slap that knocked Olivia against a wall?
Pretty much because we see the impact injury, and I still could have been thrown against the wall. But as far as the slap goes, I would say the major reason I thought it might be the slap would most likely was because of the lip injury. And so, but reviewing the records, I see that obviously was an artifact. So basically I'm backing off that opinion, but I'm still, say it's still suspicious.
Okay. And I guess my point, but every slap doesn't result in a laceration to the lip, correct?
No, of course not.
So the fact that the laceration to the lip wasn't there at the time of the injuries makes you less suspicious, but it doesn't rule out.
Testifying.
Sustained.
But does it rule out I don't want to lead you. Does it rule out the possibility that Olivia was slapped and fell against the wall?
Well, yeah, but the problem is we have to consider it would take a lot of trauma to accelerate her head that hard. And you should see some evidence of that. And initially I thought, well, maybe the lip laceration, if that occurred at the same time, would be evidence that there was enough force to do that. But in the absence of that, I didn't see any injuries on the face that would have been significant enough to cause that.
Okay. Okay, well, but I had asked you previously, are you sure that what happened is she fell down the stairs?
Well, no, I'm not sure.
Okay, so that's one possibility.
Possibility, correct.
Okay. Are there other possibilities?
Sure,
Do some of those possibilities include abuse?
correct.
Okay, that's what I'm getting at. There are multiple explanations for this same set of facts, correct?
Yes.
Okay. If the defendant in fact told the police, I'm asking this as a hypothetical, if the defendant in fact did not tell the police that she pulled Olivia's ears, or twisted Olivia's ears, but in fact told the police that she pinched Olivia's ears, and that she stopped doing that and she did that as a form of discipline, and that she stopped doing it because Olivia was scratching her ears, would that be consistent? Can I finish the question, Joe?
All right, the objection is sustained.
Okay, showing you again what's been marked and entered as states 8. You testified, I think, that looked like scratch injury.
Yes,
Would that be consistent with the child scratching her own ears?
yes.
Okay. So the state asked you about whether you were familiar with a couple of studies, stair-related injuries to young children treated in U.S. emergency departments, 1999 to 2008. Are you familiar? Have you read that study?
No, I have not.
And risk and protective factors for falls on stairs in young children, multi-center case control study. Have you read that study?
No.
That's Kendrick et al. Kendrick, Kendrick et al. ET space AL. Can I find? Two of them, please. Or no, I'm sorry. I don't need any of them. I already did. Can I get my numbers? Where we're at? Will be the next one. And, you said that that it would be important to know in looking at studies that say that only 1 in a million or 1 in 2 million kids who fall downstairs die, that it would be important to know what sample they were using, correct?
Absolutely.
Why?
Well, because obviously, if you, let's say 9 out of 10 children that fall, actually 9 out of children fall down the steps that die immediately. 9 of them die immediately. Don't make it to the hospital, don't make the emergency room. So the 1 out of 10 that makes it, if you're just using that person and not taking into account the others, I would feel more comfortable if a medical examiner's office had written this report than the
Okay,
hospital.
so if you're excluding from the universe of people that you're looking at, the dead people, then of course you're not gonna have many deaths. Is that what you're saying?
Right, exactly.
Okay, so, and the difference, I think, did you say would be whether they drew their data from hospitals or from the morgue?
Correct.
Okay, and, just for reference, I'm showing you defendants, 18. No, I'm sorry. Defendants 20. And do you see whether this report was collected from hospitals? Whether the data was collected from hospitals?
Yeah, it appears that these were injuries treated in US hospital EDs.
Okay.
In other words, they were the ones that already made it to the hospital.
It was the people who survived.
Correct.
And of course, you're not going to find many dead people among people who survived. right?
Survivors. That's basically the definition of a
Okay.
survivor.
Okay. And then looking at what I've marked for reference as Defendants Exhibit 19, do you see the methodology there?
Multi-center care control studies in hospitals, minor injury units and general practices. This was in the United Kingdom, by the way. This looks like it's from England.
Okay, but we could we assume that injuries are probably the same, that's not necessarily a factor, the fact that it was.
Right. If you're going to use the same statistics, you've got the same problem.
But you still have the same problem that they're both from hospitals, right?
Right. You're taking out a population. That's why as a scientist, you've got to be very careful. A lot of studies say a lot of things. You got to be very careful about the actual data that they're drawing from.
Dr. Feig thinks all of these injuries are consistent with a fall down the stairs. Would you agree or disagree with that?
Jack Leading and his statement of the testimony.
All right, that'll be overruled.
I would agree that the injuries that she sustained that caused her death were consistent with a fall among other possibilities.
I apologize. I said all of these injuries. You're saying the ones that caused her death. Is that right?
Yes.
And then the state asked you about the first page of State's Exhibit 18, which is the, there we go, which is the growth chart, right? And they asked you if you would be concerned that Olivia's weight had gone down as she grew. One time when she grew.
Well, yeah, but there might be a number of factors. And I would defer to the pediatrician's clinician to determine
Okay.
whether or not that was a problem.
And if the PICU pediatrician testified that he had done albumin tests and pre-albumin tests and determined that she was not malnourished, would that be a factor that you would consider?
Well, sure. Again, I defer to the clinician. They have more experience doing working in the clinical issues than I do.
Is a bruise a hematoma?
Well, essentially, yeah, a bruise is a hematoma. Bleeding in the skin. And you can have all sorts of hematomas. Don't have so is hematoma in the skin is basically is a bruise. The hematoma in the peritoneal cavity, for instance, is just a hematoma or a subdural hematoma. So it's essentially it's a clotting of blood or aggregate of blood is the hematoma. If it's in the skin, and that's why in a case where you have trauma in little bones of the nose and you get this periorbital nose thing, basically the blood seeps up inside of behind the lower layers of the skin, and that's what you see coming through the skin, as opposed to blunt force trauma where the force starts from the outside and goes in.
Okay. And have you ever spoken to Jessica Briones?
No.
Have you seen the videos of her interrogations by the police?
No, that's not something that I would be looking at as a scientist in doing the autopsy.
Okay, well, and the state asked you, in child abuse cases, do child abusers tend to claim that they're not child abusers?
Usually,
Usually, okay. Is there another group of people besides child abusers who would, if asked, claim not to be child abusers?
I don't really understand the question.
Would non-child abusers also claim not to be child abusers?
Well, of course, yes.
Okay, so the fact that somebody's claiming not to be a child abuser is not evidence that they're therefore a child abuser, right?
Correct.
Okay. Now, I want to ask you one other thing, because I think you alluded to this on cross. Even if you couldn't rule out previous abuse, and you said that the scars on Olivia's head, the
Check for leaving and testifying.
All right, that'll be overruled. Ask your question.
thanks, Judge. I think you testified that the scars on Olivia's head and the some of the other previous injuries were suspicious for child abuse.
Correct.
Okay, have you changed that?
I'm still suspicious, but I'm less suspicious that certainly that the terminal event was not an abuse case.
But that's what I'm getting at. Even if one believes that there was previous child abuse, does that tell us that the terminal event was the result of child abuse?
No, in fact, it's important to distinguish that, in my opinion. I was, in my experience, I've seen cases that look pretty bad and turn out not to be child abuse.
Yeah, what do you mean?
Well, actually, looking at the,
Sustained.
Have you ever seen cases where the physical evidence of older injuries appeared to be child abuse and yet turned out not to be child abuse?
All right, I'm sorry, could you repeat your question?
Yes, Sean. Have you ever seen cases where the older physical evidence appeared to indicate child abuse, but then on further review turned out not to be child? So that's the question, don't answer.
All right, and the state's objection will be sustained.
By the way, the state has had your name and address for years. Did they ever send you any studies that they wished you to look at?
no, I've not received anything from the state.
I'm sorry.
I've not received anything from the state on this case.
Okay. And you said that you have personally seen cases of children's stairway death, correct?
Yes,
And by that, are you talking about a fall down the stairs?
all down the stairs, yes.
Accidental?
Accidental.
Okay. And again, how many autopsies have you done?
I've done probably 7,000 or 8,000 autopsies in my career.
Have you done 1 million? 1 million autopsies?
Nobody's done 1 million autopsies.
And then if you haven't done 1 million, you haven't. Done
Even in a system where they overwork you, nobody's quite gotten that bad.
And yet how many, and I know you probably don't have this number off the top of your head, but what would you estimate the number of child stairway deaths. that he's-
Checked relevant.
That'll be overruled.
I'd probably say no more than a dozen or so.
Dozen or so out of seven or 8,000.
About 7 or 8,000.
Um. And I guess I'll just ask, is there anything I've missed?
I don't think so.
Pass the witness.
State?
Just a few more questions. Those studies defense showed you the stairway related injuries to young children treated in the US, 1999 to 2008. Basically says stairway falls are pretty benign events. Only 2.7% of children are even hospitalized. Is that correct?
Well, again, according to,
Well, that's gonna ask you.
well, I don't know. Well, that's what the paper says, but I don't know that the database is accurate enough to make that statement.
And the other published article that we showed you, and as far as I know, the stairs aren't any different in the UK. Out of 610 cases, 85% only had a single injury, 64 did not require treatment, 64% did not require treatment. 25% were treated in the ED, and only 5% were admitted to the hospital. There were no fatal injuries. Is that correct?
Well, that's what the paper says. But again,
And again, you haven't done the research, so someone who is more familiar with stairway falls in children might be better to testify about what the research says. Is that correct?
well, if I can answer the question, yes. The data that they, in their paper, they state they based on are the ones that arrive at the hospital.
And Olivia arrived at the hospital. Is that correct?
Correct.
Now you said the only additional information you've been provided is this picture of some stairs. That's it. But in your original report, which you said you still stand by, you said the findings of contusion injury to the facial area in conjunction with a recent laceration on the inner aspect of the upper lip, along with the above detailed occipital injury, represents an injury pattern frequently seen wherein a blow to the face results in the individual being propelled against an object and mitigates it being against an accidental fall. And that's what you put in your report. And again, the only new information you've had is a picture of two stairs. Is that correct?
Well, I said very clearly, I reviewed the report, medical reports again, after the report was issued, and was able to rule out as we went through that that injury to the lip, which was what I was basing my opinion on, occurred after the child was admitted. Clearly showed in the medical records that was the case. So I changed my mind based on new information that I got from the same records. Maybe I should have got it the first time, but I go back and review it. And so I don't think it's now consistent with what I said.
And defense asked you if I'd sent you any studies or any articles. Did defense tell you that I'd asked to speak with you prior to trial? They tell you that?
I didn't know one way or another.
Okay, and they didn't want me to?
I have no information one way or another about that. You'd have to ask the defense attorney. I don't know what he did or didn't tell me.
You described what's documented on the scans. So they're not looking at the external injuries that we're looking at, but the bright subperiosteal hematoma, which One of the other witnesses testified along the right orbit, measuring up to 6 millimeters in thickness. You said that could cause raccoon eyes. Is that correct?
That doesn't cause raccoon eyes. That is what can develop into what we call raccoon eyes if that bleeding continues for a long enough time, and if it was severe enough to start with.
So how long would it take to develop into raccoon eyes?
Well, it depends on how severe the injury is, how much the bleeding is occurring, how long the person survives, all those variables.
Do you have a ballpark?
No, it depends too. You can't make a guess if you have variables that you don't have control over the variables.
I'm showing you States Exhibit 179. Picture that I pulled up of someone with raccoon eyes.
Right.
Is that what you would typically see?
Well, actually, usually the eyes are swollen shut. And the hemorrhage is usually one area. That's a fairly benign raccoon eyes.
Okay, but we're looking at dark circles around the eyes.
Periorbital hemorrhage, yes.
And would that be helpful to show the jury what you're talking about with raccoon eyes?
Well, it isn't, that's the severity that's probably more severe than our case, but not as bad as it can be.
But would it be helpful in explaining your testimony?
No, I think basically what I explained is everybody understands what raccoon eyes are.
Okay. But in this picture, we're looking at someone with dark circles right around their eyes.
Well, we've been through that, yes. And those are actually red circles. If it was in color, it'd be more demonstrable.
And I'm showing you States Exhibit 119.
Yeah.
A bruise to the right side of Olivia's nose, which is documented as a bruise.
Well, we see it extending all the way over here. See, it goes into the eyelid. There's no trauma to the eyebrow, which is right above that area. So if you're being punched, the fist is going to hit here, the hardest here and here. So you're not going to have it back in the recesses of the nose.
Could you instruct the witness as to how to, he's pointing, but the jury can't see where he's pointing.
If you touch
Have a
the screen,
pointer?
no, sir, I'm sorry, excuse me, doctor. If you just touch the screen,
Can I touch it? Okay.
yes.
Thank you, Judge.
Okay, we got all this hemorrhage all the way around here. And actually, there's some over here too, you can see. So that's the bilaterality of it. So we have it on both sides. And you can see there's none on the top of the nose or the eyebrow or the cheek where a punch you'd hit that first because the eyes are way back. And this is why you've got way back into the recesses of the eye. And you can imagine how could you hit somebody in the eye, miss this part, miss this part, miss this part, and then get all the way back. And the way it's spreading over here and all the way around to what on the picture is the right side. And then we've got, rather than a distinct bruise, we've got some setting down into the nose area. And more importantly, it's on the other side as well. So I think this is a little misleading to just show the one side of the picture. But the way it's sort of feathering out, if you will, so rather than being a distinct thing, it's feathering out. And more importantly, in the nose area, eyebrow, cheek, which are the protruding parts of the face, you don't see any bruising. So that's what basically makes this diagnosis. It's coming up from behind, and that's why this coloration is occurring.
Okay, but she's not documented by the people that actually treated her or in the autopsy as having two black eyes. She's talked about having a bruise to the bridge of her nose.
Well, and also the periorbital, well, you can see the periorbital hematoma, whether it's documented or not. I thought the pathologist documented that as well. But you can see clearly this area is all that area is involved in hematoma and none of the protruding areas.
And again, she struck on the right side, and in the CT scan, you can see her nose curved to the other side.
Well, if you we looked at the CT scan actually, and you could see in the nose area there, if the nose had been traumatized, we would see a lot of bleeding. And in the CT, you don't see soft tissue hemorrhage around the nose area. Only place you see it is in the periorbital area.
So then you're contradicting.
I'm sorry, Judge, I object to the sidebar.
Sustained.
I'll pass the witness.
Defense.
The state said stairway falls are pretty benign events. That's true, except for the ones that kill you, right?
That's correct.
That will be sustained.
Are stairway falls pretty benign events?
In my opinion, in my experience, no, they can be very severe and fatal.
Okay. Can there be some that are not?
Well,
fatal?
sure. Oh, sure. I imagine kids fall down the steps all the time. That doesn't happen.
And you don't see those, correct?
No, we wouldn't see those.
I'm sorry.
Wouldn't necessarily see those.
Yeah, I mean, as a medical examiner, you're not gonna see the ones that aren't fatal, just like the clinicians aren't gonna see the ones.
Yeah,
that are.
correct. I'm just trying to, in my experience, when I was with the medical examiner's office in Orlando for the first part of the 1990s, we also participated as clinical doctors in evaluating for the child protection team. So I can't recall if I saw sort of number of falls that were not obviously child abuse, but I don't recall any stairway falls.
Okay. And again, are all of these injuries consistent with the stairway?
That's one of the possibilities. Yes.
Sorry, when I say all these injuries, the fatal injuries, the terminal injuries on.
I'm sorry, I lost your question.
Sorry, when I say all of these injuries, I mean the fatal injuries. the
Correct.
terminal. Pass witness.
State.
And the fatal injuries are also consistent with child abuse.
It could be under certain circumstances. Yes.
And if all the other evidence in the case points to child abuse and no evidence points to stairway falls,
Objection, argumentative, Judge.
That'll be overruled.
and that further supports that it's child abuse. Is that correct?
You have to look at the actual findings.
Yes, yes or no? If all the other evidence points to child abuse and not a stairway fall.
Well, it's not really a yes or no answer. It'd be misleading to the jury to answer that yes or no. And I think I've already answered all that.
Object non-responsive.
That'll be overruled.
I'll pass the witness.
Passion.
All right, is this witness excused or subject to recall?
Subject to recall from the state.
All right, the rules has been invoked. What that means is you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state and the defense. Just make sure you're available for recall
And Judge,
if
may we-
needed.
may we approach?
All right, just a second. Everyone, we'll approach you later. Just have a seat. All right, you may step down.
I can't be sure I'll be done later.
All right, you may step down.
Thank
All right, ladies and gentlemen, it is almost 5 o'clock. So maybe you can avoid rush hour traffic, who knows? But you're not allowed to discuss or deliberate about this amongst yourself and your own internal thoughts or with anyone else. If you see anything on the news or hear about anything or see anything in social media, ignore it. Do not do any research. Everything that you need to decide this case will come from inside the courtroom. Does everyone understand? And both the state and defense are allowing me to let you know that we're going to be back tomorrow. We're going to be back tomorrow at 9:30. We're going to go all day. I've been informed that there are 2 videos. One is 30 minutes long. One, some are telling me it's 5 hours, some maybe 5.5 hours. So that is to let you know that tomorrow, if possible, of course, whenever anybody needs a break, just let me know you need a break. If possible, if we could make sure that those videos are seen tomorrow. Okay. All right. Thank you all so much. I appreciate it. Everyone, please rise for the jurors.
on.
All right, so I already know what the issue is. My understanding is that he needs to go back to, where are you from, Doctor? Orlando. He needs to go back to Orlando. So here's the question. If he's needed to be recalled, is anyone going to object to that being done by Zoom?
No objection, Judge.
All right, so if you could put into the record, please, that nobody objects to Dr. Anderson being recalled if necessary by Zoom. Is that correct, State?
Yes, Your Honor.
Defense?
Yes, Your Honor.
All right, so I'm sorry, Dr. Anderson. If you're needed, it will be by Zoom, so you need to make sure you're available by Zoom. You understand?